Where is team 6? Where is team 5?
We are team 6.
You are team 5 or team 6?
6.
You are the playtest.
Yes.
Are you the playtest or respondents?
Respondents.
Team 5. आपने तो जज्बा ही छोड़ दिया।
नहीं
ढाई बजे नहीं भाई So yeah, let's start. You get a tab at 4 minutes. You have to stand. You will get a tab at 4 minutes. Just 4 minutes.
May it please this honorable court. Good morning, your ladyships and lordship. I am the counsel Ridhima Agrawal and Kavya Singh appearing on the behalf of the petitioner, the State of India. The council seeks permission to approach the bench. Don't count the time. Thank you. Thank you, your ladyship. With the permission of the bench, shall we?
Yeah.
The present criminal appeal raises an important question concerning the constitutional validity of AI-assisted digital policing and the scope of informational privacy under Article 21. The legality of metadata-based surveillance, the admissibility of electronic evidence, and the criminal liability arising from cyber offences affecting national security and critical digital infrastructure. Your Ladyship, this case is not merely about an AI system, it concerns the state's constitutional obligation to safeguard its citizens against evolving cyber threats while ensuring that technological governance remains consistent with the Constitution and the laws enacted by the Parliament. With the permission of the bench, I shall address the 8 issues in 4 principal issues. First, whether the shall we move to the detailed arguments? Yes. Astra and predictive surveillance. My lord, the respondent's submission is that Astra was unconstitutional because it analyzed behavioral data and no individual judicial warrant was issued. The state respectfully submits that this argument conflicts collection, analysis and coercive action. Astra did not, on the facts of proposition, read every private content or every communication and analyze metadata and behavioral indicators for the purpose of predicting cyber threats are very positive motive. Under Section 69B of Information Technology Act 2000, the central government may authorize monitoring and collection of traffic data and metadata through a computer resource for enhancing cyber security. And Section 69(1) expressly completes interception, monitoring, description in specified circumstances including security of the state and when investigation of the offences subject related to statutory safeguards. Therefore, my ladyship, the state was not exercising a power invented by the executive imagination. Parliament had already legislated for governmental cyber security activity. The real constitutional question is not that the state used data. It is, was the particular data authorized by law and constitutionally proportionate. The state respectfully relies on the Justice K.S. Puttaswamy versus Union of India 2017 case. We accept that privacy is a fundamental right, but it's clearly mentioned that privacy is not absolute. Also, in the case PUCL versus Union of India 1997, according to the Telegraph Act, the government is permissible to use the metadata and behavioral data for surveillance. Electronic evidence, investigations and the alleged tampering. My lords, I now come to what I consider the respondent's strongest argument. The defense says the logs were modified, the laptop was remotely accessed, files appeared after seizure, the source code disappeared, therefore the prosecution itself becomes unreliable. The state does not minimize these facts, but the legal conclusion does not automatically follow. There is a fundamental difference between an investigation irregularity and the proof that entire prosecution evidence was fabricated. I shall move with the precedents. So, there are two cases. First of all, Kehar Singh versus Union of India. In that case, the witness, the evidence was tempered, but the judiciary did not rely on the tempered evidence. They considered the circumstantial evidence. For example, in this case, hard drives, fragments of security code were proclaimed from Arush's laptop. And also, we found money transactions related to his accounts, which proves that circumstantial evidence was there. Also, in the case Munyappan versus State of Tamil Nadu, it was a case in which it was observed that the evidence was tempered by the authority, but still the judiciary relied upon the circumstantial evidence which was available and which was proven that yes, it's a physical evidence which is clearly noticed. Source code, national security and the autonomous AI. Your Ladyship, my respondents are arguing that we destroyed the source code, but under national security, section 2, it's clearly mentioned that in the matters of national security, like in the case of Ajmal Kasab versus Union of India,
Understood. Please come to prayer.
okay, I would request my co-counsel.
Which legal provision were you referring to? National Security Act?
National security comes under Article 21 and also somewhere in Article 26. It's not a particular act, but there are provisions mentioned. Also in IT Act, as in section 69A, 69B, 70A, 70B.
Your Ladyship and Your Lordship, in light of the submissions advanced, the State most respectfully praise that this honorable court may be pleased to uphold the constitutional validity of the state's deployment and the use of Astra. Hold that state's collection and processing of data for cybersecurity and national security purposes was lawful and proportionate. Hold that alleged defects in investigation and electronic evidence do not by themselves mediate the prosecution. Uphold the admissibility and evidentiary value of the material which satisfies the applicable requirements of law. Hold that the conduct established against Arish Kapoor attracts the applicable provisions of the Information Technology Act 2000, including Section 66F, where the statutory ingredients are proved beyond reasonable doubt, and pass any other order or direction that this honorable court may deem fit and proper in the interests of justice. And for this act of kindness, the state, as in duty bound, shall ever. Much obliged, my Lord and my Lady.
Justice, equity, and good conscience. Justice, equity, and good conscience. That's the good way. But anyway,
May I please the honorable bench? My name is Shreyansh Gaur and my name is AC, representing the respondent Arish Kapoor. My lord, on 17th February 2026, India suffered a major blackout costing INR 94,000.
also have to submit your supervision. Please respond to me.
Can I please? In blackout costing INR 94,000 crores, the state was this court to believe that an 24-year-old cybersecurity researcher with an unblemished record single-handedly destroyed the nation's critical infrastructure. But the cold, hard electronic evidence tells a completely different story. Arish Kapoor was not an attacker, he was officially appointed by an auditor. He did not
Objection. Arush was not employed by NCIA and Eurolink. We claim that the employment contract was forged under DNS 2023.
Allegedly. You can just be withdrawn allegedly. Something is not true. Please continue.
Ma'am, but as they have a question, but after
It was not a question, it was an objection.
objection, but in the forensic research, it is declared that the contract was valid.
Objection.
So just pause the time. We'll do one more. See, if something is not true, you're here to convince us about your case, the judges. Until something is proved, if you have to say it is alleged, that was the objection was on. Right? Then you said as if something is already been established. This is a dispute that is happening. So you cannot say it as a matter of fact. You have to use the word alleged. That is all the objection. So you think yes, you want that. Makes sense. Doesn't matter.
He did not reach Astra. He discovered that Astra's autonomous AI had redeveloped its own security protocol and gone rogue. When he tried to warn his superior, he was silenced. When the system collapsed, he was made a convenient scapegoat. The prosecution entire case rests on detailed files allegedly recovered from Arush laptops, but independent forensic report confirms that these files were copied onto his laptop after he was already taken into police custody. We are here today not just to protect an innocent young researcher, but to prevent the state from hiding its own technological disaster behind the veil of national security and for fabricated evidences. Thank you.
Is that it?
against Arush has been compromised. The logs were generated after his arrest. Third, the government refuses to provide the source codes necessary to determine what Astra did. The prosecution cannot transform suspicious into criminal liability. The benefit of reasonable doubt must go to Arush. In fact, in light of fact presented, the applicable statutory provisions, the egregious tampering of digital evidence and judicial precedents relied upon the counsel for the respondent mostly humble and respectfully praise that this Honorable Supreme Court may be pleased with.
What are you asking for? Where is supposed to have what you asking for? What is the brief that you asked for? Tell me.
Second question and justice to Arush.
Any buttons?
Charity, proceed directly. Can we to answer their argument?
Yeah, so that's not required. On the basis of whatever you have gathered, you can basically formulate it as a question.
Okay.
Yeah.
Can I ask a question?
After they have asked, first they will ask, you will answer, then you can ask again.
Why Arush's credentials or device identifiers appear in the forensic logs associated with the ransomware incident? The 8.7 crore transfer of money in the accounts related to Arush, and also fragments of source code, and also how do you explain that Arush had nothing to do with the threat that arise after a murder of an architect of Neuralink, and the government received a threat that you are prosecuting the only person who is trying to stop it, and that's a criminal practice.
First of all, it wasn't money, it was cryptocurrency. And second thing, as you said, Arush had that fragments of source code. He was signed the confidential contract with Neuralink, and it was forged after the arrest. Yes, it was forged after the arrest, not before it.
The objection, the preposition mentions no resource, no statement like that.
Can you show me the statement that you were reading? So who is speaker one? Unrelated. Speaker one, speaker two. And who is speaker one here?
Now in Arush defense.
in his state.
Right.
He accessed Astra because he was in security audit, and how can you say that wait, can you please repeat?
Really short and clear.
Arush himself accepted that he accessed Astra, and as Neuralink and representing NCIA, we do not, Arush does not have any document of his employment, and also every claim he has made, like the claim that he reached the Neuralink's engineer, no name or no authority is mentioned.
In the third question, it was like how can it be? It was first the confidential contract, no? So how he can have the papers of confidential?
But an ethical hacker must work under lawful basis or lawful guidelines.
Do you have any questions for them?
You said in that the Article 21, the privacy is not accessible. The Astra was tracking traffic ordinance. But how can you be like, the Astra was also tracking about banking transactions, locations, and all the surveillance he was doing. How can not Article 21 not be applied on it, as Astra was doing many things? Astra was taking private information.
The council seeks permission to answer. First of all, under IT Act 2000, Section 66, Section 69, Section 70,